Next month, a woman from Arkansas will stand before a judge, accused of allowing a man to inflict harm upon her own young daughter. We will unravel how this alleged abuse came to light and examine the troublingly inadequate response that Kelsey Ann Ezzy reportedly showed towards her daughter's suffering. This is Sidebar, presented by Law and Crime. I am Jesse Weber. This week, 26-year-old Kelsey Ann Ezzy posted a $25,000 bond following a felony abuse charge. Shockingly, this reportedly continued even after social services explicitly warned her to keep the man away from the child. According to the probable cause affidavit, a Hot Springs police detective received a call from the child abuse hotline. The caller reported that this man, already known to police, was allegedly abusing a young girl. Though police have prior encounters with the suspect, his identity remains under wraps, shielding him from public knowledge for now. The following day, a Department of Human Services caseworker visited Ezzy's home, delivering a stern directive. The male suspect was forbidden any access or contact with the victim. He was not allowed inside the house, and Ezzy herself was prohibited from communicating with him. The affidavit states that Ezzy acknowledged these restrictions and promised to comply while the investigation proceeded. Yet shortly thereafter, new bruises appeared on the girl's arm. An investigator from the Arkansas State Police Crimes Against Children Unit accompanied a Hot Springs officer to conduct a forensic interview with Ezzy's daughter. The child disclosed that the man squeezed her arms and revealed the bruises to the detective. Kelsey Ann Ezzy, 26, is accused of allowing a man to physically abuse her young daughter, even instructing the child to lie about her bruises, claiming, "The dog fell on me." What deepens the tragedy is that this man was living under the same roof as the girl and her mother. The girl confirmed they were present when she left for school that morning. Photographs documented multiple bruises, and a warrant was swiftly issued for Kelsey Ann Ezzy's arrest on charges of permitting child abuse. In Arkansas, this constitutes a Class D felony, defined as the act of allowing abuse of a minor when one is responsible for their care or custody. The law states that if a parent or guardian recklessly fails to prevent abuse, especially when it causes physical injury or involves sexual contact, they are subject to criminal charges. Authorities indicate that if convicted, Ezzy could face up to 6 years behind bars. Despite the gravity of the charges, she was released on bond. Her court appearance is scheduled just before Christmas. To explore this case further, we invited Professor Marian Brasha, a seasoned law professor at Temple University and director of the LLM Trial Advocacy Program. Professor Brasha graciously joined us. She shared her initial impressions of this troubling situation. Expressing concern, she acknowledged the commonality of such cases in child abuse investigations. She emphasized that many of these tragedies could be averted through stricter enforcement and better cooperation among social service agencies and law enforcement. The professor underscored the heartbreaking reality for the child, who desperately needs a dedicated advocate. One pressing question she raised was whether those responsible were fully aware of the danger the girl faced and the abuse she endured. She stressed that mechanisms should have ensured the suspect was kept far from the child. The allegations must be accepted as true. The mother's assurances that the man would not return should have been trusted only cautiously. Professor Brasha questioned whether law enforcement and social services had effective tools to intervene, or if they were left hoping the worst would never come to pass. She insisted this could never be a mere hope. Instead, she argued, all involved agencies, law enforcement, social services, family courts, must collaborate closely to protect vulnerable children and guarantee a safe environment free from abuse. This demands rigorous communication, follow-up, and accountability from social workers and case managers to ensure no child falls through the cracks. To be clear, these remain allegations. Kelsey Ann Ezzy has not yet been found guilty. Professor Brasha noted the sensitivity required in cases involving child witnesses, highlighting the risk of causing further trauma through the court process. This consideration weighs heavily on prosecutors. They must balance the pursuit of justice with the potential emotional toll on the child, who faces the harrowing prospect of testifying against her own mother. Such experiences are profoundly difficult for a child to endure. These realities shape the prosecutorial approach in this heartbreaking case. The child's exact age remained unknown, raising serious questions about her ability to serve as a competent witness. Prosecutors faced the burden of proving, before any testimony could be admitted, that she possessed the necessary competence to testify. This meant demonstrating that she understood the gravity of telling the truth, could distinguish fact from falsehood, and was able to recall and accurately recount past events in detail. Crucially, she needed to grasp the difference between reality and fantasy to ensure her testimony would hold up under scrutiny, meeting the standards required of any witness taking the stand. A pivotal issue arose regarding whether the child would be required to testify in court. Earlier, the conversation had touched on legal provisions in several states, including Arkansas, that allow for testimony to be obtained without forcing a young alleged victim to face the courtroom directly. This exception to the usual rules of evidence was particularly noteworthy and warranted further explanation. In Pennsylvania, where one of the experts practiced law, this exception is known as the tender years rule, a legal safeguard for vulnerable witnesses. As is often said in American courts, if you have something to say, you say it in court. This principle underscores the preference for direct evidence. The justice system demands that witnesses personally recount what they have experienced and observed. Witnesses are expected to be examined and cross-examined, so their credibility can be carefully evaluated. The court assesses memory accuracy, potential biases, and any vested interests in the case's outcome. This process emphasizes the value placed on live, in-person testimony. Yet the system recognizes that the courtroom can be an intimidating place for a child. The pressure of testifying may overwhelm a young victim, making it difficult for her to relate and recall traumatic events clearly. In Arkansas, the law includes a residual exception designed for such circumstances. If a judge determines the child cannot testify live, this provision allows for an adult to speak on her behalf. This adult could be a nurse who examined the child or a social worker who noticed the injuries. They would testify about what the child disclosed, such as naming the male suspect as the cause of her injuries and alleging that her mother instructed her to say the dog was responsible. This narrow and controversial exception offers prosecutors a potential route to present critical testimony without the child testifying directly. Yet this legal maneuver raised questions about its possible benefits for the defense. If the child were to take the stand, fierce cross-examination by a defense attorney could influence the jury significantly. The child's undisclosed age raises concerns about her ability to testify competently, but Arkansas law allows an adult, such as a social worker or nurse, to recount her statements, avoiding direct courtroom testimony. Questions arise about the accuracy of what was told to the adult. Why was this information shared? Could the adult's perspective be biased? It sparked debate over whether allowing such testimony might actually advantage the defense. One expert acknowledged this possibility. A defense attorney might find it easier to aggressively challenge an adult professional witness, such as a social worker or nurse who is trained to handle intense questioning. Yet it was emphasized that any witness's credibility is subject to exposure during cross-examination. This is the core purpose of that process. However, from a constitutional standpoint, the defense typically objects to allowing an adult to testify for the child, citing the Sixth Amendment's Confrontation Clause. In a criminal case, the accused, in this instance Kelsey Ann Ezzy, has the right to confront her accuser, who is tragically her own child. The defense would argue that only direct questioning of the child herself satisfies constitutional requirements, not second-hand testimony from an adult recounting the child's statements. Therefore, despite any strategic advantage, the defense would prefer the child to testify in person. This preference aligns with evidentiary rules and constitutional protections. When pressed to consider the defense's possible arguments, the experts explored potential strategies. What defenses might the accused mount? The answer was not simple. The defense would demand to know where these other witnesses were if the abuse occurred in their presence. Alternatively, the defendant could claim ignorance, insisting the bruises were hidden from him or that he was simply not present when the injuries were inflicted. He might maintain he had no knowledge of the abuse at the time. He would deny any awareness of how the child was hurt. But the child's account, that the dog caused the injuries, revealed a troubling implication: knowledge of an effort to conceal the truth. Ultimately, the case would hinge on whether the fact finder believed the child's testimony. Physical evidence confirmed the presence of injury. Yet, the true challenge lay in uncovering how those injuries were inflicted. The case would ultimately hinge on the defendant's account. It was not simply a matter of facts, but a test of credibility between conflicting stories. The next question turned to the defense strategy. What options remained available for the accused? Could the defendant choose to plead guilty and avoid the uncertainty of trial? From a human perspective, one stark piece of advice was clear: never force a child to take the stand and relive the trauma. Pleading guilty could lead to some leniency, sparing the defendant from the risk of a lengthy prison sentence if the case proceeded to trial. What might a plea deal actually involve? What would pleading guilty mean in similar cases of alleged child abuse? The implications for a parent admitting guilt in such a case were profound and complex. In a gut-wrenching dilemma, the parent must weigh the anguish of forcing their child to testify, knowing that their attorney would cross-examine the child, challenge their memory, and attempt to undermine their credibility. This deeply personal consideration should weigh heavily on any parent accused of abusing or allowing harm to come to their own child. Many factors influence a prosecutor's willingness to offer a plea deal, perhaps a lesser charge or reduced supervision or incarceration, rather than pursue a full trial. Critical unknowns remained: the defendant's prior record, any past involvement with social services, prior abuse allegations, or previous investigations into the household. Additional criminal history, even unrelated to child abuse, would also shape the prosecutor's decisions on charges, plea offers, and potential penalties. The case was still in its infancy, with many complex layers yet to unfold. As the conversation drew to a close, gratitude was expressed to Professor Marian Brasha for her insights. Her expertise brought back vivid memories of law school days, moments of challenge and growth, reminding us all of the gravity and importance of legal education in cases like this. The reunion was warm, underscoring the human side of the legal world. Though difficult to discuss, the case demanded attention. The time given by Professor Brasha was invaluable. With a nod to the ongoing need for legal education, an open invitation was extended for future discussions. As this episode concluded, viewers were thanked for their attention. The audience was reminded to subscribe on popular podcast platforms to stay informed on future investigations. Jesse Weber signed off, promising to return with more stories yet to be told.